Ready, start. This court, in a very recent judgment of Rinku Baheti versus Sandesh Sarda, held that the factual analysis has to be undertaken in each case to determine as to what constitutes an single inverted comma irretrievable breakdown single inverted comma close while keeping in mind the non-exhaustive factors laid down in Silpa Salis within bracket supra bracket close full stop. But what constitutes an irretrievable breakdown has to be determined in each case by undertaking a factual analysis of the case and using judicial discretion in light of several non-exhaustive factors laid down by this court in the judgment of Silpa Salis full stop. This court has to reach the conclusion that the marriage has double inverted comma completely failed double inverted comma close off and there is no possibility of the parties cohabiting together as husband and wife and that the continuation of the formal legal relationship of marriage is unjustified lacking in substance and content full stop. Considering the above principles, we need to consider the factual matrix in the instant case before arriving at a decision on the application filed by the appellant under Article 142 of the Constitution of India. Full stop. The marriage between the appellant husband and the respondent wife was solemnized on 19th February, 2018. Full stop. It is not in dispute that the spouses resided together for a short duration of 80 days in the USA and have been living separately since May, 2018. Full stop. The respondent wife is residing in Tripura, India, and on the other hand, the appellant husband has been primarily living in the USA, for the last 5 years. Full stop. It is also to be noted that multiple cases have been filed by the respondent against the appellant and his family members, as recorded in para 5 of this judgment. Full stop. The appellant and his family members have also filed numerous cases against the respondent. Full stop. As can be observed from the above list, the parties and their family members have indulged in multifarious litigations against each other, even though the period of the spousal relationship was very brief, and the discord started way back in 2018. Full stop. The respondent filed a complaint case number 1009 of 2018 under section 498A IPC against the appellant and his family members. Full stop. In addition to the said complaint, the respondent has registered a matrimonial suit number 280 of 2018 under section 9 HMA, seeking restitution of conjugal rights. Full stop. The respondent had also filed a complaint case number 444 of 2020 under sections 405, 406, 407, 420, 378, 499 and 500 IPC against the appellant, her mother-in-law, and 5 other family members. Full stop. Apart from these cases, the respondent filed 2 complaint cases bearing number 698 of 2021 within bracket against the appellant's family members bracket close and number 699 of 2021 within bracket against the appellant bracket close, under sections 31 and 32 of the DV Act. Full stop. The filing of the aforesaid cases by the respondent wife reflects her vindictive attitude towards the appellant and his family members and unambiguously reflects the bitterness that has seeped into the marital relationship. Full stop. The tumultuous state of the marital relationship between the parties is quite evident, irrespective of the fate of the criminal complaints and the imputations made by the parties against each other. Full stop. The passport of the appellant was also impounded by the concerned authorities, pursuant to the pending cases filed by the respondent. Full stop. The appellant and his family members have also filed various cases within bracket criminal complaint cases, title suit case, eviction suit, money suit, domestic violence case, and divorce case bracket close against the respondent before various courts full stop. Further, Srimati Gayatri Shah within bracket the old aged mother of the appellant bracket close has alleged that she was brutally assaulted, and her modesty was outraged by the respondent, and that she has been ousted from her own house by the respondent on 14th September, 2020, full stop. Resultantly, she was constrained to file a complaint case number 446C of 2020 against the respondent under sections 323, 341, 342, 379, 403, 504, 506 and 120 BIPC full stop. Thus, the old aged mother-in-law has also been entangled in the litigations spurted owing to the matrimonial discord between the appellant and the respondent, which also has an evident impact on the mind of the appellant in how he perceives the acts of the respondent and his relationship with her. Full stop. Whatever may be the justification for the spouses living separately, with so much time having passed by, any marital love or affection that may have developed between the parties seems to have evanesced. Full stop. This is a classic case of irretrievable breakdown of marriage. Full stop. The admitted long-standing separation, nature of differences, prolonged and multiple litigations pending adjudication, and the unwillingness of the parties to reconcile are evidence enough to establish beyond all manner of doubt that the marriage between the parties has broken down irretrievably, and that there is no scope whatsoever for marriage to survive. Full stop. Apart from the irreconcilable status of the relationship between the parties, in the present case, another factor that has weighed with this court in favor of the exercise of the power under Article 142 within bracket 1 of the Constitution of India is that there is no child born from the wedlock, and therefore, any direction to allow the parties to part ways would only affect the parties themselves and not any innocent child. Full stop.